happy Monday, and welcome to this Conservative Education Reform Network web event on Title IX and the legal backlash there too. I'll begin by posing a few questions. One is, what is a woman? Two is, what is sex? And three is, what is the Administrative Procedures Act? You will, over the course of the next hour, hear provisional, at least, answers to all of these things and more, now that we are a few weeks out from the Biden administration's Title IX regulation, which, amongst other things, redefines sex to include things such as gender identity, changes due process requirements for allegations of sexual assault on campus, and potentially chills speech in an unconstitutional fashion. So we will get into all of these issues with the panel of experts that I think we are kind of thrilled and certainly privileged to hear from and have with us. And the hope is that anybody who has heard of the subject, heard of this controversy, will be able to walk away from this webinar with about as concrete and effective an understanding of what the legal issues are and where things might be headed as anyone in America has right now. So with that, I will, instead of introducing our panelists all at once and risking you all not remembering, I'll kind of introduce folks as they talk, and I will turn it over first to Thomas Wheeler, who has had a kind of a long, storied and very varied career in education policy. He has been a senior counsel to the Secretary of Education. He has been at the DOJ. He has been at the National School Boards Association, amongst many other things. And so I will turn it over to Tom to kind of set the broad table for us.
Thanks, Max. Sean, if you could start the screen share. While they're starting the screen share, kind of what I've been asked to do to see where we're going, it's a good idea to take a look at where we've been. And with that, I want to kind of talk about how this issue has been framed and kind of the left has been working on this issue going back to 2011. Sean, could you advance, please? So this is a brief timeline beginning in 2011 and bringing us to 2024. Over the last 13 years, there's been a lot of movement, and what you'll see over the next couple of slides is certainly a very partisan issue. It's an issue that has moved back and forth depending on which administration is in power. In this case, the Obama administration started things off. Sean, next slide. April 4th, 2011, they issued a Dear Colleague letter. One thing you need to understand, a Dear Colleague letter is what we call sub-regulatory guidance. It is sent out by the Department of Education. It doesn't go through really any administrative review other than an internal administrative review. And it is directed to the school community to indicate how the department is going to interpret certain things. In this case, this was a Dear Colleague letter signed by the head of OCR, indicating that in terms of campus sexual harassment, essentially, they were recommending stripping the due process rights of students accused of campus-based sexual harassment, kind of a star chamber procedure. Next slide. So they followed that up on May 13, 2016, and this is the second piece. That was the sexual harassment piece. This Dear Colleague letter involved transgender students. It was interesting in two regards. If you noticed on the last Dear Colleague letter, that came only from the Department of Education. This Dear Colleague letter was jointly issued by the U.S. Department of Education and the U.S. Department of Justice. And I think that's significant, and that's why I put the names of the two individuals involved down there. Catherine Lehman, who was the Assistant Secretary for Civil Rights, she headed up OCR. And then Vinita Gupta, who was the Principal Deputy Assistant Attorney General for Civil Rights. And what they did and they intended to do was to create more of a legal background for these Dear Colleague letters. They knew, and there were a lot of objections. I certainly raised objections. I was the board director on the board of directors for the National School Board Association and chaired their council of school attorneys when the 2011 Dear Colleague letter came out. And we objected to it, basically saying, this is your guidance, but we don't have to follow it. So I think they thought by putting the Department of Justice on there, they got more bang for their buck from a legal standpoint. And this pairing, Catherine Lehman and Vinita Gupta, is one that we're going to see again as we move forward. But the Dear Colleague letter, transgender students, essentially sought to redefine the use of the term sex in Title IX to mean gender identity. They pushed it broadly across sex segregated activities, facilities, and athletics, etc. All that we saw later in the regulation. Next slide, please. The problem with the Dear Colleague letter is that it only stays in place as long as the administration that produced it does. In this case, at the beginning of the Trump administration, the Gavin Grimm case had gone up from the Fourth Circuit to the U.S. Supreme Court. The Fourth Circuit had given what's called our deference to that Dear Colleague letter from Lehman and Gupta and said, well, the DOJ and the Department of Education, they're interpreting their own regulations, and therefore we will give deference to that. The word sex now means gender identity. As the case was pending in front of the U.S. Supreme Court, my name's on the withdrawal letter, as is Candace Jackson from OCR. At that time, I was the Assistant Attorney General for Civil Rights. We rescinded the portions of that letter related to bathrooms and locker rooms, which mooted the GG case and brought the case back down into the Fourth Circuit, kind of the first shot in undoing kind of the Obama era guidances. Next screen, please. On May 6, 2020, this is the second one, and Bob Eitel and Kim and Christian are going to talk a lot more about this because they were architects of this. Rather than do it by Dear Colleague letter, as the prior administration had done, our administration went through rulemaking process and issued a final regulation, Title IX regulation on campus sexual assault that restored some notion of due process to the Title IX investigation, Title IX investigators, and gave some rights back in these Star Chamber proceedings. Next slide, please. Having learned a lesson from what we did, what I think has been referred to occasionally as the third term of the Obama administration, everything old is new again. Catherine Lehman went back and is now heading up the Office of Civil Rights after a brief stint at the Domestic Policy Council, the DPC. And Vanita Gupta actually moved up to the number 3 position at the Department of Justice, the Associate Attorney General. They went through their own rulemaking process and generated a rule. I put up former Secretary DeVos's quote on the DFI website, a little advertising for Bob Eitel and his shop. With that, let me hand it back to you, Max.
Great. Fantastic. Thanks so much for that overview, Tom. And one of the most talked about aspects of this is the kind of the rewrite or the redefinition of sex to include gender identity, which is a term that the regulation itself kind of refuses to define. So to get into kind of how that was done, what that means, and how that might hold up, I will turn it over to Kimberly Ritchie, who was Deputy Assistant Secretary in OCR under DeVos, is now a Senior Chancellor in the Florida Department of Education, and so has kind of experienced and stands to experience this issue from several perspectives. And looking forward to your comments, Kim.
Thanks so much, Max. It's so good to be here with all of my former colleagues and with you today. I really appreciate the opportunity to participate in this important discussion. So, as both Max and Tom have alluded to, one of the most significant changes, though it's not unexpected in the Biden administration's new rule, is its expansion of the scope of Title IX rules so that discrimination on the basis of sex specifically includes gender identity and sexual orientation. There are really two parts of the rule that I want to point you to today, and we can kind of dive into what those look like. The first is 106.10. And this is the section of the rule that relates to scope and application of the new rule. What this new part of the rule states is discrimination on the basis of sex includes sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. So it's the categorical inclusion of both sexual orientation and gender identity without the department actually defining those terms. What this means is that all forms of sex-based harassment that are prohibited by the rule as forms of sex discrimination are going to be applicable to students and employees based on both sexual orientation and gender identity. So in addition to broadening the scope of the rule, the department at least partially eliminates longstanding provisions of Title IX that have allowed for both the separation of individuals on the basis of sex and the different treatment of those individuals. So since its passage for decades, Title IX has allowed schools to separate students on the basis of sex as an exception to the non-discrimination provisions of the rule. This is why schools have separate athletic teams. It's why they have separate restrooms. It's why they have separate locker rooms. Well, there's a new part of the rule, section 106.31, that specifically pertains to the different treatment of individuals on the basis of sex. What the rule states is that in those limited situations where different treatment or separation is permitted, a school cannot carry out different treatment or separation in a way that discriminates on the basis of sex by subjecting a person to more than de minimis harm. So the department creates this standard called the no de minimis harm standard. Now, there are two stipulations to this no de minimis standards rule. The first is that the department identifies limited exceptions in which the no de minimis harm rule will not apply based on the reasoning that Congress permitted sex separation in these specific instances, even if it caused de minimis harm. So within this exception bucket, the department points to two statutory provisions and one regulatory provision. The two statutes are 20 USC 1681, which sets forth very specific exceptions to Title IX, admission to certain programs, different military institutions, the religious exemption. So religious entities where compliance with the Title IX rule would actually conflict with the religious tenets of the educational institution are all included here. This specific statute includes exceptions for sororities and fraternities, for father-son and mother-daughter activities. It's a specific set of exemptions where Congress has said these are okay even if they cause de minimis harm, at least according to the department. The second bucket is 20 USC 1686, and this is the specific section of Title IX that pertains to sex-separate housing. The third exception is actually a regulatory exception, which I mentioned, which is 106.41b. And this is the only regulatory exception in the rule based on the theory that Congress approved this section by its inaction because it failed to disapprove this regulation when it was submitted to Congress under the Javits Amendment. And as most of you probably know by now, I'm referring to the athletics section of the Title IX regulations. So what the department is saying is in those areas where Congress authorized separation or different treatment based on sex, the de minimis harm standard does not apply because Congress allowed for the different treatment, even if there is de minimis harm. And again, those are specific exceptions: dorms or separated sex housing and athletics under the 106.41. So what's interesting is the other caveat or the other stipulation to the no de minimis harm rule actually states that in all other matters, in all of those other areas where different treatment or sex separation is permitted, any policy that prevents a person from participating in the education program or activity inconsistent with their gender identity causes more than de minimis harm. So the department is saying you have to let, in all other areas where you separate by sex, you have to allow individuals to participate consistent with their gender identity, because failure to do so causes more than de minimis harm. So it's a categorical determination without looking at the evidence, without looking at the facts of a case, that if you don't allow an individual to participate based on their gender identity, that you have caused more than de minimis harm. So most of you are probably wondering by now, right? Like what's left over. And I think this is the really important part of the conversation. So what the department does not specifically address in the text of the rule are those intimate facilities that are not included in exemptions that are outlined under the rule. Things like locker rooms, restrooms are the most notable. And it is true, as Max mentioned, that schools will be required to allow both students and employees to access those intimate facilities consistent with their gender identity, because failure to do so would cause de minimis harm to those individuals. And again, restrooms and locker rooms don't fall into any of the congressionally recognized exemptions that the department has set forth in the rule. I do think it's funny, Max, and I just want to point out before I hand it back to you that the department was sure to point out in some of the preamble language that nothing prohibits a recipient from voluntarily allowing individuals to participate consistent with their gender identity, even in those areas where Congress set forth a specific exemption. Including athletics. The other thing I just kind of want to point out, and I feel like we're certainly getting a lot of questions about this, and it pertains specifically to privacy types of issues. And I think this is important because the department talks a lot about FERPA in the preamble to the final rule. As most of you know, FERPA is the Family Educational Rights and Privacy Act. It's the federal law that protects our student records. It's the federal law that gives parents and students access to their educational records. What the department states is that the obligation to comply with Title IX is not alleviated by FERPA. So the department points out that if a recipient has to comply with Title IX and that might cause a conflict with FERPA, Title IX is going to trump any rights under FERPA. And I think this is really important and really pertinent because, as you know, there are a lot of parental groups out there that have already felt like schools are using their non-discrimination obligations under federal civil rights law to keep information from parents. And so I think that the department emphasizing this fact, I think is just going to kind of further perpetuate those concerns by parents. We could talk all day about this, Max, but I'll turn it over to you, and we'll talk more in questions.
Yes, absolutely. Fantastic. Thanks so much, Kim. And now we're going to turn to Bob Eitel of DEFI, the Defense Freedom Institute. Bob was a senior counselor to Betsy DeVos. Under the Trump administration, he was a major, I think it's fair to say, architect and engineer of the Title IX regulation. And then once he realized that his great work, in my personal opinion, was going to be undone, he didn't particularly want to see it undone and has spent a lot of his time kind of as a watchdog over and kind of advocate on behalf of more sound policies coming out of the Department of Education. So Bob, I'm curious, like we've talked about the gender identity thing that has flashed in the headlines, but like what other elements of this law, this regulation are at stake? What else should people know, and what else is kind of in legal contest right now? You're on mute, Bob.
Max, thank you. I appreciate being here today. I do have to give a recognition and shout out to two individuals who were intimately involved in drafting and writing the Title IX regulation that Secretary DeVos published, and that is particularly Candace Jackson and Will Trackman, who are not with us today on this webinar, but have spoken eloquently about these issues, and they were valued colleagues. What I'd like to talk about, Max, are two issues that percolate throughout these regulations, and they relate to the change in the definition of sexual harassment to one based on a notion of sex-based harassment, as well as issues relating to due process consideration in connection with grievance procedures, disciplinary proceedings arising in educational institutions from supposed Title IX violations. So let's talk a little bit about how the 2024 final rule has changed the definition of sex-based harassment under the law. In 2022, the DeVos rule was very careful to structure a definition of sexual harassment that sort of hewed the line between redress for individuals on campus who needed to file a complaint about unacceptable sexual misconduct, but which also considered the importance of free speech, academic freedom, First Amendment responsibilities that educational institutions have to face. So there was a three-part test that was created, or I should say, there were three types of sexual harassment that were identified by the 2020 rule. And the first category of sexual harassment related to quid pro quo type of harassment, whereby a school employee conditioned an educational benefit on participation in unwelcome sexual conduct. So the terrible situation where a professor or teacher demands sexual relations with the students in return for a grade, that sort of thing. That was conclusively prohibited, obviously. The second category was also very obvious, those relating to sexual conduct, I should say sexual misconduct, such as sexual assault, dating violence, domestic violence, stalking, as those terms were defined in certain other statutes known as the Clery Act and the Violence Against Women Act. The third category, the third bucket, related to conduct that was not sexual assault and not quid pro quo harassment, but was unwelcome conduct that a reasonable person would determine is so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the school's education program or activity. That was a standard carefully taken from Supreme Court jurisprudence that considered the First Amendment implications of sexual harassment based on speech. Flash forward to the Biden administration's Title IX regulation that has just been published, and lo and behold, they've made a critical change to that definition. First of all, it's no longer just sexual harassment; it is sex-based harassment. They do retain the quid pro quo harassment and the sexual assault type of offenses within the rule. That's totally appropriate. But they go on and they have changed the standard for unwelcome conduct. And so they have changed the standard to be a sex-based harassment that includes unwelcome sex-based conduct that, based on the totality of the circumstances, is subjectively and objectively offensive and is so severe or pervasive that it limits or denies a person's ability to participate in or benefit from an education program or activity. The department concedes that its new definition of sexual harassment is broader than the definition in the 2020 rule and the Supreme Court case that rule relied upon. To sum up the differences, the 2024 rule applies even if the harassment merely limits a person's ability to participate in the educational program rather than denies a person's access to that program. The rule expands Title IX to cover harassment that is severe or pervasive rather than simply severe and pervasive as the 2020 rule did. So these are sweeping changes, and they're going to add to concerns that people have concerning the standard relating to notions of free speech on campus and academic freedom. We can talk about that a little bit later. What I'd like to do now is turn quickly to the issues of due process under the rule. There are many substantive changes to the due process requirements that the 2020 rule includes, and I'm going to go over a few of them now. Some of the worst, what I consider to be some of the worst changes. Preliminarily, one thing I want to note is, this is just a mystery to me why they would do this, but under the 2020 rule, educational institutions are obligated to post their Title IX training materials on their websites. They have taken that out of the rule. It's no longer a requirement. Parties can ask for these training materials, but as a proactive requirement, schools are no longer required to post their training materials on their websites. And I'm just totally perplexed by that change. Why would you change that if you're trying? I mean, one gathers from that they're trying to make it difficult for people to obtain training materials for Title IX coordinators, which is a mystery to me. I mean, that is the sort of thing that any student want to see, any interested party, any alum would want to see, and to be able to examine if they have an interest in these issues. One of the worst changes that the current administration has made to the 2020 rule is that they are reviving what is called the single investigator model, which allows the decision maker to be the same person as the Title IX coordinator or investigator. So the 2020 rule barred this model of Title IX enforcement that combined the notion of the cop investigator, the judge as fact finder, and the jury as sort of the adjudicator or decider of the penalty. All those roles under the 2024 rule are now combined. Another change that the current administration has made is that the new rule no longer gives respondents the right to know in detail the allegations of a complaint, of a concern about sex-based harassment prior to the time they are interviewed by the Title IX coordinator or their designee. The 2020 rule required schools to give respondents sufficient details known at the time and with sufficient time to prepare a response before an interview, including the conduct that might constitute the alleged sexual harassment. The current rule says that an institution must only provide written notice to the parties whose identities are known with sufficient time for the parties to prepare a response for any initial interview. That's a very different standard, and it means that respondents, persons who are facing sexual harassment complaints, will not have detailed allegations given to them prior to being interviewed by the Title IX office. Another bad change is that the current rule no longer requires access to evidence compiled during an investigation. You can ask for the evidence, but the school is not entitled as a requirement to give it to you. They are only required to provide a draft investigation report that accurately summarizes this evidence. And so if you don't know these rules, you're not going to know to request the evidence. You're going to end up getting, a parent or student is going to end up getting just a draft report and summary. They're not going to know to request all the evidence. That's a problem. I think it's, for those who are following this issue, it's well known that the new rule requires schools to use a preponderance of the evidence standard in connection with disciplinary proceedings to determine responsibility for a supposed violation. That is a departure from the current rule, which allows schools to choose between the preponderance of the evidence standard and the clear and convincing evidentiary standard. The only condition in the 2020 rule was that schools simply had to apply the same evidentiary standard for students, employees, that which they used for faculty, which is only fair. Under the new rule, schools are directed to use preponderance of evidence standard unless they use a clear and convincing standard for all other quote unquote comparable proceedings. So most schools are going to end up using a preponderance of evidence evidentiary standard. The rule also does away with the requirement that post-secondary institutions have conduct a live hearing. They are allowed to have them under with certain conditions. Most, as a result, because they're no longer mandatory, will not have these live hearings. In connection with this issue of factual determination, the new rule allows investigators to ask questions during individual meetings with the party or a witness in lieu of live hearings. Parties can propose questions for the investigator or decision maker to ask, but the investigator or decision maker don't have to ask the proposed questions. So the Title IX coordinator or designee who has control of the investigation will be deciding whether the questions submitted by a party should be asked or not. And then under the single investigator model, they will be determining responsibility and penalties. You can see the unfairness that ekes out and drips from this rule. One good thing about this rule is I do retain the 2020 rules requirement that schools be allowed to offer informal resolution of Title IX complaints. One difference, though, is that the current rule does not require that a person concerned about sexual harassment actually file a complaint in order to access informal mediation. So you may have a situation where mediation is used perhaps as a weapon or where there's frivolous demands for mediation. We included a requirement for a formal complaint to ensure that informal mediation was only being employed in cases where actual complaints were being filed to underscore the importance of the proceeding. There's a lot more I can go into. I'll stop now. There's issues of universal jurisdiction here concerning Title IX, standing for complainants, a whole bunch of things that we can talk about. So I'm going to hand it back to you, Max.
Well, great. And thanks so much. And so as you all can see, these are just immensely conceptually different things that this regulation does, from regulating and mandating access to locker rooms to how to adjudicate allegations of sexual harassment and assault on campus. And as Tom Wheeler had kind of pointed out, this is downstream of the Obama administration kind of deciding, okay, after 40 years, these words in Title IX mean X. Oh, and also after 45 years, these words also mean Y. Then you had the Trump Department of Education come in, say, actually, these words neither mean X nor Y. And now we are having the states step forward and say, no, these words really don't mean X or Y. And so 22 states at my last count have currently filed suit against the Department of Education, contending with a variety of claims, contending this regulation should not stand. One of those states is Montana, and we are lucky to have the Solicitor General of Montana here, Christian Corrigan, who is also a senior counsel to the Assistant Secretary in OCR under the Trump administration. So Christian, too, has kind of seen both sides of this regulation and its potential implementation. So Christian, I'm curious, from your perspective on the regulation and where things stand broadly with the course of legal action.
Yeah, thanks, Max, and to AEI for the opportunity to participate. I was actually an AEI intern way back in the spring of 2008, so it's an honor to be a part of programming now. And grateful to my colleagues, former colleagues and friends for being here with me. Yeah, so this has been, I would say right up there with the COVID vaccine mandates in terms of the most controversial rules of the Biden administration. To my count, we've got 7 lawsuits now filed in 6 different federal courts. As you mentioned, 22 states, as well as nonprofits, 18 school districts, private plaintiffs. And I expect that there will be more in the coming days and weeks. That was at least just the first tranche. I think that, the rule does have a number of substantive and procedural legal vulnerabilities. So just a brief overview for everybody. Title IX is a rule promulgated by the Department of Education. Congress passes statutes which give agencies the authority to make rules. And federal rules are generally governed by the Administrative Procedures Act, which require rules most of the time to go through what's called notice and comment rulemaking, where the agency puts out a proposed rule, the public comments on it, and then they release a final rule. And as part of that final rule, they put together a document that explains what they did, how they did it, what they did or didn't consider in response to what the public submitted. And the Administrative Procedure Act requires courts to set aside agency action that's arbitrary, capricious, or an abuse of discretion, or otherwise not in accordance with law. And what that really means is that I can put the legal challenges broadly into two buckets, as I mentioned earlier, substantive and procedural. And so the first bucket we'll consider are substantive challenges. So these are the arguments that the rule does something illegal, or in the parlance of the APA, not in accordance with law. And I think that there's probably broadly about 6 subcategories here. The first big one, which won't surprise anybody, and Kim discussed it and you discussed it, Max, is that the rule illegally incorporates the concepts of sexual orientation and gender identity into Title IX, and that itself is an illegal rule. Wrapped up in that, you have various arguments that forcing females to compete with biological males denies them equal access to education programs and activities, and forcing boys into girls' locker rooms itself constitutes a Title IX violation. Second, you have a number of claims by the states, which are that the rule forces states to implement a federal program that conflicts with state law and forces states to violate their citizens' constitutional rights. Third, you have claims that forcing students and teachers to use preferred pronouns violates the First Amendment rights of students and teachers. Fourth, you have claims that it illegally lowers the liability standard for sexual harassment, as Bob explained. Fifth, you have claims for vagueness that say the various provisions lack objective standards. This is going to bleed into some of the procedural claims I'll discuss later, but essentially it doesn't put individuals on notice of what's going to constitute a Title IX violation. And then sixth, as Bob discussed just now, there are claims that this violates due process and reinstitutes the kangaroo court system from the Obama administration. Now, the two big ones that I'm going to get into right now are the first two categories, incorporating sexual orientation and gender identity into the word sex, and then into the term sex, and then the claims by the states that it violates the 10th Amendment and state sovereignty. Now, there are various legal doctrines out there that lawyers for plaintiffs and the government are going to use to debate whether the term sex includes sexual orientation and gender identity, and how much deference the federal government gets to define those things. But I think the one that's most salient is a doctrine that many of you might have heard about in the last couple of years called the major questions doctrine. And to keep this very simple, the idea is that major policy decisions come from Congress, not federal agencies. And if Congress is going to make a federal policy decision like of that magnitude, it has to say so expressly. So when reviewing courts look at these rules, they're going to look to see if the government is taking an established statute and sort of claiming some broad new sweeping power that Congress couldn't have possibly intended. And we've seen this invoked in the student loan bailout context, the COVID eviction moratorium context, and the OSHA vaccine mandate. And I think the definition of sex is absolutely a major question, and maybe we can get into why more specifically during the Q&A. But relatedly, one of the reasons why Title IX is so unique compared to other cases where the courts have said agencies lack the power to radically change the landscape is that Title IX is a spending clause statute. And a spending clause statute is akin to a contract with the federal government, where the federal government essentially says, hey, here's a bunch of money, but nothing's really free because there are conditions attached. And by accepting this funding every year, you agree to do certain things. And one of those things is to not discriminate on the basis of sex and comply with Title IX. And so if the states don't comply, you're talking about tens of billions of dollars of federal funding at risk. Now, the Supreme Court has said this power is broad and the federal government gets a lot of latitude to attach conditions, but it's not unlimited. And you can't just surprise states with what the conditions are, and you can't do it so much as to coerce them. And I think it's clear that there's no way these conditions on the definition of sex were clear when states accepted the money. And it's not good enough now to just say, well, you're on notice. You know, the original public meaning of sex in 1972 is the same as it's been from the beginning of time, male and female, And Ed can't just magically redefine that now for the states and say, if you want our money, you have to accept that. That's not how the spending clause works. The second big bucket are procedural requirements. So the APA, or Administrative Procedure Act, prevents agencies from making decisions that are arbitrary and capricious or an abuse of discretion. Now, legal jargon aside, what this means is that agencies have to actually explain their decisions, put forth rules that are internally consistent, and they have to show their work. They have to show that they meaningfully considered input from the public during the comment period and explain what they did and what they didn't consider. So first, as was discussed earlier, the big liability here is that the rule fails to define the concept of gender identity. Because it's not just about men becoming women and vice versa. It's actually many other things. I mean, I've seen one list that says there are 107 genders, and who knows how many there'll be by election day. But with something so subjective, the administration didn't even bother to tackle what really is a core problem with the entire concept of gender identity. Now, I find this particularly interesting in light of the fact that the department claims that it should receive deference on defining sex because it actually has expertise on how to define sex discrimination under Title IX. So in essence, they're saying you'll know it when we see it. And this also relates to some of the vagueness challenges that I mentioned earlier. Second, as we discussed with athletics just a bit ago, they have a real problem where on the one hand, they're saying, oh, this rule doesn't affect athletics, but anyone who can read or has any common sense knows that this obviously has to affect athletics. Again, it's worth mentioning that the separate proposed athletics rule they've held in abeyance and likely are going to hold that until after the election when it's more politically palatable. But this is a major consideration the rule has papered over. And then finally, as Tom mentioned, one other unique aspect of this rule versus other rules is who's doing the rulemaking. You know, when presidential administrations switch back and forth, it's not uncommon for policies to change. The states see this all the time. If a statute gives an agency the power, for example, to set the air quality level, the standards might go up and down based on who's in power. And of course, there's always legal challenges over those. But in general, if the procedural process is legal, then the rule is valid as long as it complies with the statute. But here we have kind of a unique situation regarding, in particular, the due process provisions. As Tom and Bob discussed, the impetus for Secretary DeVos undertaking the historic 2020 rules was the Title IX guidance that was put out during the Obama administration, where OCR was led by Assistant Secretary for Civil Rights, Catherine Lehman. And if you think about it, she's really the ace of spades who's most responsible for the kangaroo courts and the widespread reporting on what a disaster that was. And there's an article from The Atlantic, of all places, that quoted former OCR investigators saying that the perceived message from Washington was that once an investigation into a school was open, the investigators in the field offices were not meant to be objective fact finders. Their job was to find schools in violation of Title IX. And then it got even worse in the Biden administration, because Catherine Lehman is now back at her old job overseeing the rulemaking process as Assistant Secretary for Civil Rights again. And when the 2020 rule came out, she said that it, quote, takes us back to the bad old days when it was permissible to rape and sexually harass students with impunity. Now, keep all this in mind against the backdrop of the Administrative Procedures Act, which requires agencies to keep an open mind and consider the evidence before them. So the point we made in our comment was that she should have recused herself from the rulemaking process because she can't possibly be objective about repealing the 2020 rule, given her statements that she made, and given that she personally instituted the policies that caused the mess on college campuses. And she clearly believes that, one, her past mistakes weren't mistakes, and two, the 2020 rule wasn't justified, despite there being widespread condemnation of the system she put in place across the political spectrum, from the likes of the ACLU and the Harvard Law faculty. So look forward to questions. Thanks for the opportunity.
Great, fantastic. So I will kind of take the moderator's prerogative and ask the first few questions. We also absolutely welcome audience questions. You can email them to Sean Doolin, whose email is on the website for this event. You can also tweet them, hashtag AEI Title 9, and that's 9 with a 1X, Roman style. So I will, throw the first question open to any lawyer in the room. One thing that we've heard, and it's a little bit technical, right? But like the argument that the regulation makes is that this is entirely consistent with the Bostock decision, right? And that they rest a lot of their legal arguments on that. And I'll just briefly characterize the Bostock decision, explain what I think is the opening between the two, and then just ask anybody to reflect on it, right? So Bostock was in the context of Title VII, not Title IX. It was in the context of employment, and it more or less held that, you know, if Kim decides that she is a man and decides that she is going to dress in a suit and assert that she's a man, you can't fire Kim for dressing like a man because you wouldn't fire Kim for dressing like a man if she were a man. And so sex is a but for of her being fired, and therefore that kind of violates you know, the spirit of discrimination on the basis of sex. Now, the Supreme Court ruling explicitly said it was a Title VII decision and did not extend over. B, there seems to be a little bit of daylight between that and Kim being a student who decides she wants to be called Ken, and then me calling her Kim, and then the school being in violation. There just seems to be a little bit of a slip between kind of those two fact patterns in addition to the logic. So I'm curious, I mean, maybe for one of you all to first try to steel man their arguments and then to hear what, you know, the argument against Bostock controlling here is.
I'll jump in, Max, and then hopefully Bob will weigh in, because I feel like we've had a lot of hours of conversations about this, both with Bob and Christian. So yeah, I think that you raise a really good point, right, Max? And, you know, I think that you kind of outlined some of the arguments about why Bostock should or should not apply. And to be honest, I think the department just kind of skirted around those. I don't feel like there was a strongly articulated legal basis that responded to the commenters' objections or the commenters' concerns. So those folks that did not or do not believe that Bostock is a legal basis or a legal justification for adding sexual orientation and gender identity, they relied on various arguments. You know, what was the meaning of sex at the time of the adoption of Title IX? They pointed to the differences between Title VII and Title IX. They looked at the differences between the educational and employment environments, including the differences in ages, right? 5-year-olds versus adults. And, you know, I think they ignored 3 key things. The court specifically declined to expand Bostock to any other federal anti-discrimination laws. As you mentioned, the issue was framed very narrowly. And, you know, Ed just did not find these arguments persuasive. In fact, their response was, well, Title VII has always informed Title IX. Their response was, you know, even though there's a difference in the language, courts have used the language interchangeably. So they say on the basis of sex and because of sex interchangeably. They pointed to the fact that Title VII also allows for differentiation between the sexes, right? And so their position is that sexual orientation and gender identity are so inextricably intertwined with biological sex that was their basis. And at the end of the day, I think what they argue is that adding sexual orientation and gender identity is necessary to effectuate the purpose of Title IX, i.e., we can't really protect students from discrimination on the basis of sex if we don't add sexual orientation and gender identity. They say that it results in greater protections, and they say it's consistent with Title IX's purpose. And you know, it was just the opposite position than what we took during the Trump administration.
Hey, if Max, this Tom, can I jump in before Bob jumps in? Because I want to cite people to 2 things. One, what makes their position so perplexing is that we issued in January through the general counsel's office a detailed analysis of why Bostock did not apply. Reed Rubenstein did it, and it's very detailed, and it always perplexed me that they never really responded to it. So if anybody is looking for those arguments from the department at the time, the copies are still floating around of that opinion. Number one. Number two, if you can't find it there, if people are looking for these arguments in a nutshell, look for the comment letters that the attorney generals did, we addressed them in some detail. I know the attorney general groups that I was working with addressed them in some detail in our comment letters, not as much in the complaints, but in those comment letters, because I think that distinction of Bostock is going to be a key spot that we're going to be dealing with in, as Max mentioned, the litigation, at least initiated by the attorney general's groups, because we're prepared to make those distinctions, as Christian knows. I'll toss it to Bob because you were called out. It's kind of like a debate.
I was simply going to add that what struck me about the preamble to the final rule was it seemed to discount the 11th Circuit jurisprudence that directly considered sex-separated bathrooms in Title IX, and found that sex-separated bathrooms based on biological sex are perfectly valid under Title IX. It's the Adams case. And here you have a case that directly deals with Title IX in a way that the department differs. And their analysis of the case is simply to say, well, we simply don't agree with that, and move on. There's no real analysis. If you look at the preamble, there really isn't any real deep-seated analysis as to why. There was simply a continued constant embrace of Bostock, a Title VII case relating to a transgendered individual, and not necessarily gender identity as a concept, and a complete disregard of the Adams jurisprudence that recently came out of the 11th Circuit, which is much more on point than Bostock.
And Max,
Bob,
I think that even if you agree that Bostock applies to situations where the sexes can be separated, and you applied that narrow Bostock test, it still doesn't get you to where the department ended up, which is any policy that doesn't allow you to participate on the basis of your gender identity is a per se violation of Title IX, because it subjects you to more than de minimis harm. Like it's not even an accurate application of the Bostock test, I think.
Great.
Let's face it, Title IX and Title VII are completely different statutory regimes. Different purpose. No minors involved. We can have a discussion at length about it, but go ahead, Max. Sorry.
All right. No, another kind of question and issue that I want to frame up, because it's been a subject of a lot of kind of public debate and controversy, is this idea of the intersection between Title IX and the First Amendment, specifically with regards to, misgendering, amongst other things. So, if Bob decides that he identifies as a woman and his name is now Barbarella, and I call him Bob once, that is, according to the text of the regulation, fine. I'm allowed to misgender him in a stray way. But if I continue to call him Bob instead of her Barbarella, and I do this several times, then it seems, according to the regulation, the school at which I am a student or a teacher would have a major problem. Which would mean that the school would need to prevent me from calling Bob by his name, which would seem to pose a certain First Amendment problem to me, whether I were a student or a teacher. So I'm kind of curious, again, just kind of to lay it out there, kind of what their argument is, because I've read it. They say that they don't see a big First Amendment issue here, and then kind of for at least one of y'all's arguments as to what happens when the anti-discrimination tenets of this expanded Title IX do butt up against kind of, I think, pretty well understood First Amendment protections.
Well, what's going to happen is that speech codes are going to develop. That's how institutional entities comply with the law. They develop internal compliance protocols and policy based on the statute and the regulatory authority. And the way that many educational institutions will deal with this is that they will look to sort of codify internally, how do I implement this regulation? How do I implement this department's interpretation of this law so I can avoid liability, so I can avoid a risk of non-compliance? And what they will do is that they will come up with a speech code. And the speech code will say, in part, thou shalt not misgender. And then therein you run up with some real issues of not just free speech, but also religious liberty. If I accept and believe that God made man and woman, and there are two sexes, and they are biological, and they are different, and one cannot be the other. Under that speech code, in the way apparently the department interprets Title IX, I will not be able to articulate that belief without running risk of a Title IX violation. And that is particularly problematic. Now, there is a religious institution exemption under Title IX, and so schools which are controlled by religious organizations will be able to escape this. But there are many people who are religious who attend secular institutions who will be facing this problem at K-12 and the higher ed level. So that's one observation, and I don't want to monopolize the time, so for the others.
Hey, Max, if I can jump in, and actually, Bob, you
Absolutely.
hit the back point of it, because I think where they're going, the free speech, First Amendment applies differently in K-12 and higher ed. All right, both to teachers and students, and it is far more restrictive of teachers in the K-12 space when they're speaking in their capacity as teachers. They do not have the freedom to speak that has been afforded to college and university professors. So there will be a much stricter speech code, as Bob's talking about, at the K-12. So it'll hit harder in terms of misgendering and things like that at the K-12 space. Similarly with the kids are going to be the free speech rights of kids in K-12 are very, very limited from a First Amendment context compared to those at higher ed. So I do think at least from the K-12 space, this gets into kind of a different topic about teaching kids at a very early age certain social mores and beliefs. At the K-12, I think their confidence in their ability to control the message is probably more warranted than in the higher ed space. Let me say it that way.
Great.
Max, I would just add, I think everybody's exactly right here, but I think one of the other things is that given, regardless of what the threshold is for what constitutes harassment, this is going to turn the Title IX coordinator into the speech police in the same way that the old system turned the Title IX coordinator into the dating police to try to be, proactive and the chilling effect that's going to have on speech. And then second, one thing to point out from the state's perspective is my state and a number of other states have state laws which expressly prohibit students and teachers from being compelled to use preferred pronouns that don't match biological sex. And so this is luckily, this is one of the issues where state governments were proactive and saw this coming in the last 3 years and realizes they needed to build some guardrails so that students and teachers, weren't, alone when it comes to this. But it's definitely a big concern.
Just one other item in this vein I want to make sure that the viewers understand, Max, and that is this. There's this Title IX coordinator. It's been in the law since the mid-70s. It's been non-controversial, up until, the last 10 years or so in the way they've been deployed. But this rule really does change the role of the Title IX coordinator in a just a massive way. To the point where I refer to them as a Title IX monitor. They are to monitor as a roving patrol person what is happening on their campus in order to prevent sexual harassment or sex-based harassment from happening, and actually sex discrimination, period. Looking for barriers to reporting sex harassment, sexual harassment, sex discrimination. And it's a tall order, but their latitude to enforce and prevent issues is very broad, and it's going to be a problem.
Great. So I think we have time for 2 more questions, if I can and hold you all maybe 2 or 3 minutes past the hour. First question from the audience is I'll direct it as per the audience member to Christian at first. I'll modify it a little bit, and then Christian can answer it in full or throw it over to his friends as well. You had mentioned in your remarks that these regulations should fall under the major questions doctrine. The regulation itself, it contests this, and it says, this isn't like that. That was just about us saying you have to do this thing with $500 billion worth of the economy. This is not, command and controlling $500 billion. This is just defining a word that'll affect schools. So it's not a major questions thing at all. So I'd like you to respond to that. And I'd also like, there's a lot of kind of stirring debate about, oh, Chevron deference is going to be limited, eliminated, curtailed. Agencies won't just get to say anything else. But I haven't heard, that concretely what we might think that will mean for the course of this litigation, which, that's going to come out as this litigation is pending. So I'd love maybe starting with you, Christian, to comment on both, is this really a major questions thing? And what would the practical and theoretical intersection with Chevron deference's curtailment mean for this?
Sure. So yeah, you're correct that the preamble to the final rule does discuss the major questions doctrine, and they essentially say this is unlike West Virginia v. EPA, which is sort of the arrival of the major questions doctrine, even though the tea leaves had been there for a couple of decades. What's really interesting, though, is that the preamble fails to mention probably the most significant major questions doctrine case, at least in this context, which is Biden v. Nebraska, the student loan bailout case, where the government was trying to use a post 9/11 statute to let the Department of Education forgive $400 billion in loans. And so we have a two-part test that the court put forward that the administration doesn't even discuss in the preamble, which is amazing to me. But we look at the history and breadth of the authority that the agency has asserted. And I think our discussions about why Title IX only incorporates biological sex, fit very nicely into there. And then second, we look at the economic and political significance. And so as far as the political significance goes, we've talked about this before, but I think you'd be hard pressed to find an issue that's generated more political debate and controversy over the last few years than gender identity, and specifically men playing women's sports and sharing intimate facilities. And then second, as far as the economic threshold, you're talking about tens of billions of dollars a year in state funding, 10 to 20% of state education funding. Because Title IX is a spending clause statute, it's amazing that the department doesn't even discuss in their major questions doctrine discussion that states might lose billions of federal funding. So I think there's a lot of great reasons why this is a major question. And then secondly, you asked about Chevron. So you're correct that Chevron may be curtailed. It may even be pared back, or it may even be eliminated. What's interesting is the major questions doctrine tends to operate outside of Chevron. So when we're not talking about a regulation that is, let's say it's ambiguous, there's a lot of law professors out there, and a lot's been written on it, how exactly the major questions doctrine interacts with Chevron, non-delegation doctrine, all of those legal theories. But I think ultimately, certainly, if the government makes a Chevron-style argument that the term sex is ambiguous and they're entitled to deference, Chevron being curtailed or eliminated could help them, or could eliminate that argument. That said, the position of the administration has not been that the term sex is ambiguous. It's been that sex incorporates gender identity, and we as the agency are allowed to explain what sex discrimination means on behalf of the agency, and we've done this for 50 years. So it'll be very interesting to see how the litigation goes, but I'm interested in my colleagues' thoughts as well, to the extent we've got time.
This is Tom. I'm going to jump in just real quick because this is the pattern that they've taken all the way along. When we started with the 2011 Dear Colleague letter on the definition, when we were at the, I think it was Rosin Ali came and talked about it to the National School Board Association. We went to her and said, look, your definition in here of sexual harassment does not comply with Davis versus Monroe. All right. It is not severe pervasive is the standard, and you as an agency cannot take that standard. And they were very frank with, they said, look, when we do our investigation, we don't have to follow Supreme Court precedent. It was very clear that they intended to use our deference to change the precedent. And I think that's precisely what they're trying to do here, building upon the Chevron deference with respect to the definition, again, as Christian thing, but this is clearly an MO of going back, Rosin Ali, Catherine Lehman, and Vanita Gupta, and building on these to make these changes in spite of the Supreme Court.
Great. And then we're almost 5 minutes over, so I'll ask one final question that only one of you at your voluntary choice can be in the hot seat for, and that is simply, what do we think is going to happen? We have a lot of lawsuits in play. What is, the likeliest course of events over the next 6-12 months?
I nominate Tom Wheeler.
When I do this slide, when I do this discussion, I have my concluding slide is a picture of Biden and Trump. Number one, depends on the election. All right. If the election goes one way, they can do it. When we came in, we flipped sides on the GG case, among others. Certainly the department can, Gavin Graham, sorry. Yeah. Certainly that can happen. So one, it's the election. We took the Martinsville case up to the Supreme Court on intimate facilities. They chose to defer. I think they're looking perhaps for an athletic case coming up. But I think the litigation, and Christian, you can speak to this too, the state litigation is probably one or more of those, or Bob, you're leading a group too, is probably going to get fast tracked and force the Supreme Court to take a hard look at what the word sex means in Title IX. Bob, Christian?
No, I couldn't have said it better.
Well, great.
Yeah, totally agree.
Max, I just want to point out that,
Yeah.
like these policies can't change every 4 years. It's not practical for schools they can, like, it's whiplash. Like, we can't keep going back and forth on this. So, I mean, to Tom's point and to Bob's point, to Christian's comments, this is going to have to be settled by the Supreme Court at some point. We can't keep going back and forth on this.
Great. All right. Well, on behalf of AEI and our community and the Conservative Education Reform Network, I want to thank everybody who showed up, and thanks to all the panelists in particular. I think this has been a very enlightening and hopefully very useful conversation. And folks will just have to kind of stay tuned to see how the events at national political level and the courts unfold in the months to come. So, thank you all, and have a great evening.
Thank you.
Thank you.
Thank you.